Hi everyone, Vibracada, still finishing off on the commercial mediation topic. So here, what happens if mediation fails? Here are the options for businesses when no deal is reached. Okay, so having spent over 3 decades immersed in the world of insolvency, business recovery, turnaround, me, Vibracada, I know that not every negotiation leads to a handshake. I know that really, really well. I've done so many mediations in my life. Sometimes, despite best efforts, a mediation doesn't result in a settlement. Today, we're going to be addressing a crucial scenario. What happens if mediation fails, and options for businesses when no deal is reached. Whilst commercial mediation boasts a high success rate, it's important to be prepared for the possibility that a resolution might not be achieved. My experience spanning over, as I said before, 36 years has given me deep insights into navigating these challenging situations without necessarily resorting to a winding up petition or a liquidation. If mediation concludes without a settlement agreement, it doesn't mean it's the end of the road, but rather it's a fork in the journey. Here are your primary options and here are your next steps, okay? So you need to reevaluate and re-engage, possibly with a different mediator. Sometimes the issue isn't the core dispute, but the approach and the dynamics of everyone involved. Number 2, take time to reflect on why mediation failed, where positions are maybe too rigid. Was there a new information on the surface? Maybe other circumstances. It might be worth re-engaging in mediation at a later date, perhaps with a different mediator who might bring different perspective to the dispute. Then you've also got the option of pursuing litigation. For many businesses, the default next step after failed mediation is to proceed or resume litigation through the court system. Your solicitor and your legal representative is likely to pick up the case where it was left off, potentially initiating formal court proceedings, discovery, and ultimately preparing for trial. This path is often more costly, time-consuming, and public, with a risk of an imposed decision. You can even consider arbitration. Arbitration is another form of alternative dispute resolution that might be suitable for your next steps. Unlike mediation, an arbitrator acts more like a private judge, hearing evidence from both sides and then issuing a binding decision, which is called an award. It's typically faster and more private than court proceedings, but you lose the control over the outcome that mediators and mediation can offer. So you can negotiate directly again, sometimes the mediation process itself, even if it's unsuccessful in reaching a full agreement, can clarify issues and narrow down the points of dispute that you started with. This newfound clarity might open the door for direct negotiations between the parties outside the formal mediation settings, potentially leading to a resolution. Or, finally, you can walk away. A strategic and non-pursuit. In some areas and some cases, after thinking about how much cost and how much time has been spent, people then decide just to walk away. A business might strategically say, look, I've done the best, I've done my best, I'm not going to waste any more time on this, and just walk away from it after a careful legal and financial analysis. I always say to people that because I've been doing this for 36 years, I have provided a unique perspective on insolvency related disputes, teaching me that even when mediation doesn't yield an immediate settlement agreement, it almost always provides valuable learning, insights that inform you of your next strategic move. Don't view it as failure, you've learned something along the way. We champion constructive commercial dispute resolution. If you're ready to take the next step towards an amicable settlement, contact me at Navigate Business Recovery for expert mediation guidance and advice, because it will make you a world of difference.